Good morning, everybody. Thank you very much for joining us, and welcome to this webinar in our Shoesmiths Shared and Halved series on COVID-19 affected topics. And as you know, we're calling it that because we believe a problem shared is a problem halved. So I'm Sebastian Price, I'm a partner in the Shoesmiths Commercial Group, and I'll be moderating today's webinar. So the Shared and Halved programme, it's being run across Shoesmiths. It's bringing together different interest groups to share thoughts, insights, raise questions. So this is one in the series for in-house lawyers. And the aim is to help each other in this in-house lawyer group to deal with the challenges brought by COVID-19. And as we see in the news, glimmers of possible vaccines and testing, let's hold on to the thought that this is going to end, it will end. Sure, we probably expect that things are going to be very different when it does, but it's going to end in some shape or form. So let's make sure we're ready for when it does end. And to help with this, I'd like to point you to our main COVID-19 hub on our website. And as well as that, we've created a number of online community hubs. So there's a special one for you, for in-house lawyers, where we'll be putting useful resources such as key takeaway notes from this webinar, or even a recording of this session, articles, anything useful, briefing papers, and also information on future webinars for you. And we'll be in touch in due course after this session with details of that hub. So, in line with that concept, this webinar is one of a series for in-house lawyers, as I say, on COVID-19 themes. And they're based on the many questions we've received from you. So this morning, we're looking at supply chain issues, and thanks for the questions on that you've already sent in. We're going to try and answer them all. As ever, I can't promise they'll all fit into the session, but we'll try a way to find a way to answer as we can. And if you have questions during the session, please use the chat or the Q&A function, and we'll try to get to them in the session. So let me introduce the panel. John Smart is a partner in the litigation team and advises on complex, high-value commercial disputes, and he's recommended in Legal 500 and Chambers. He's got particularly focuses on contract and supply chain litigation, and he contributes to LexisNexis and PLC chapters on contentious issues in all sorts of agreements, distribution agreements, and terminations. And Kate Draper, she's an associate in the litigation team, advising all sorts of national and international clients on commercial disputes of all sorts. So I suppose what I'm saying is they both totally know their stuff. Right, John, can I turn to you and ask, just to kick us off with what you see are the key practical issues facing businesses in supply contracts at the moment?
Thanks, Seb. I suppose in many ways it's been a perfect storm. You have the reduced demand for certain types of goods, restrictions on travel and rules on social distancing, which have all made the performance of many goods and services contracts either financially unviable or practically very difficult to deliver. I think businesses have found themselves at risk of financial loss flowing either from non-performance by suppliers or non-payment by customers. And I think that the impact of COVID-19 hits so many different contracts poses a unique problem for IHLs because there's a huge number of contracts which may have potential issues brewing. So I think for me and a lot of my clients, it's been prioritising that's been absolutely key. There have been lots and lots of law firms and lots of barristers giving fantastic academic analysis of force majeure clauses and what they mean. But I think the challenge for an IHL is to triage what to do with a portfolio of sometimes hundreds, if not thousands, of contracts. And I think what we've seen a lot of people doing is focusing on your key contracts to ensure you serve and contest any force majeure notices correctly, and understanding that there is a risk if you adopt a one-size-fits-all approach, which may negate the protection that you're looking to. And I think it's been really difficult because I think the key takeaway is that in good times, force majeure clauses have been viewed as little more than boilerplate. But in fact, when the going gets tough, they are in fact the express allocation of risk between the parties of an event like COVID-19, which just no one saw coming.
Okay, so Kate, what contractual tools are available for businesses to resolve those sorts of issues?
Yeah, so I would always, in the first instance, make sure that you are referring back to your contract to establish what your contractual options are before deciding what to do next. Remember, every situation is different and every contract is different. So there's not going to be one right answer that fits with every scenario and every situation. The options that I'm going to talk about now are by no means a definitive list of options. They're just the type of things for businesses to have at the forefront of their minds right now, given the current climate. So I'm going to start first with force majeure. The first thing to say about force majeure is that it's not implied by common law in England. So you're going to have to look for an express clause within your contract if you want to rely upon force majeure. Secondly, just because you do have a force majeure clause in your contract doesn't automatically mean that a force majeure event has in fact occurred. The courts interpret these clauses really strictly, so the specific wording of your clause is key. So in the first instance, look to see if your contract includes a specific list of events. So for example, if disease or epidemic or pandemic are covered as force majeure events, then it's very likely that coronavirus is going to be covered. But this is quite unusual to see in contracts, because what you normally have, and as John mentioned earlier, is you see in many contracts that a force majeure provision has been included as kind of a standard boilerplate clause, which probably means that instead what you've got is a really broad clause that doesn't explicitly provide for the event that you're seeking to rely upon. In those circumstances, it's then going to come down to an interpretation of the clause and whether the parties intended the event to be covered, which obviously can be a lot harder to prove. If you can establish that a force majeure event has occurred, though, the next thing that the party wanting to rely upon the clause is going to have to do is it's going to have to prove that the force majeure event is the event that's preventing it from or hindering its performance of the contract. If it can do that, if it can show that a force majeure event has occurred, and that event is hindering or preventing its performance of its obligations, then the obligations which the party is being prevented from performing are either suspended or, subject to what the contract says, may come to an end altogether. So as an example, many suppliers at the moment are currently restricted from undertaking non-essential services or aren't able to continue operation due to the current lockdown restrictions. If this is covered as a force majeure event, then typically this will mean that the supplier won't be held to be in breach of contract for failure to supply goods or services. The second tool that I'm going to talk about is termination. So if, for example, you have a supplier who's failed to supply you, or if you've got a customer who's failed to pay you, then you can always look to terminate for non-performance and seek damages. But again, I stress, go back to your contract, make sure that you are considering the express terms carefully before you do anything to ensure that grounds to terminate do exist. And if they do exist, make sure that you're following the correct procedure for termination, because of course wrongful termination of a contract is in and of itself a breach, which of course you want to avoid.
What about something like insurance, Kate? Would that help?
Yeah, so in terms of non-contractual tools, insurance may well help. Most businesses will hold relevant business interruption insurance, so it's worth checking your policies to see if you're covered. Often these policies do contain exclusions for viruses or cover named diseases only. So as a new disease, coronavirus might not be covered, but you might find that your policy includes other events or covers other events such as acts of government, which could also be phrased as any law or action taken by government or a public authority. So in the current circumstances, government imposed restrictions and closures of businesses in certain industries may well be covered. So it's always worth checking your policies, and if you think you're covered, then conversing with your insurers as soon as possible. And then as another, following on from that, as another non-contractual tool, you could always speak to your suppliers and customers. Enter into negotiations with them and see if a commercially pragmatic solution can be reached. As a nation at the moment, we're all having to deal with the impacts of coronavirus. No one's escaping it. All businesses are being impacted in different ways and to varying extents. But all businesses are going to want to ensure that they keep their key contracts and relationships going, and that they're still there. So when all of this is over, they still have those contracts and relationships in place to carry on. So I would strongly encourage talking to customers and suppliers. By opening up a dialogue and taking a pragmatic approach, you might actually achieve a better outcome than, even if you have contractual remedies such as termination would.
Right, okay, thanks very much. And John, I know all sorts of people have come to us with difficulties and problems with trying to put those kinds of tools into effect. But in your experience, what are people typically getting wrong, John?
Yeah, it's a good question. I think Kate's given perhaps a cause for optimism, and I'm going to rain on everyone's parade. I think, firstly, I think a lot of people are looking at force majeure where a contract becomes more expensive or less profitable, but actually the contractual supply or goods could still theoretically be performed. And I think generally the fact that a contract will be financially less attractive to perform won't constitute a force majeure event unless there's really clear wording in the contract. I think the second common, I suppose, mistake or error is that don't necessarily assume that your force majeure obligations are the same as the other side's. Contracts are very, very frequently asymmetric. And if the force majeure clause doesn't help your side of the contract with your obligations, ultimately the protection of any force majeure clause could be lost. I've really seen a lot of clients come to us in the last few weeks looking to escape contracts for a reason of force majeure, but actually, unfortunately, the clauses they are looking at only offer benefit to the other party and not to them. So ultimately, if you're able to deliver your side of the bargain, many clauses won't help you. And I think, thirdly, it's almost going back to what Kate was saying earlier. Be careful what you wish for, because a lot of force majeure clauses start the clock ticking on termination rights. So, it's fairly common for a clause to say, for example, either party could terminate after 30 days of a force majeure event continuing. As such, if you need that contract to keep going, you may need to think outside of the box as to how to commercially come to a resolution, or give the other side an opportunity to terminate what might be a really valuable contract to the business. And I suppose, concluding on a more pessimistic note, as a litigator always does, I think the practical tip's got to be that, the courts won't step in to fill in any blanks in a contract. Everyone was caught unaware of the consequences and the fallout of COVID-19. But that doesn't mean the courts will have any sympathy if you're ultimately left out in the cold because of gaps in your contract.
Okay. And as well as force majeure, there's been quite a bit of chat about frustration. Is that an alternative? How would that work?
Yeah, and it's normally the next best thing. If you don't have an express force majeure clause, people tend to turn to frustration next. Now, broadly, the test for frustration is that an event occurs that somehow renders contractual performance fundamentally different from that contemplated by the parties. Now, inevitably, every case will turn on its own facts, but I think the touchstone is you're looking at impossibility, and it's a really, really high bar. The best example I can raise is a case that dates back to the 60s. And for the last 10 years, I've rolled this case out whenever we've been looking at frustration with clients. And it was a contract for delivery of goods through the Suez Canal. And the court held that it wasn't frustrated when the Suez Canal closed, because theoretically, a voyage around the Cape of Good Hope was still possible and would not have produced a performance fundamentally different from that contemplated by the contract. Now, for me, and for almost a decade, that single case is the one that I most frequently cite to clients as indicating that impossibility bar is really, really high. So I think ultimately a contract's not going to be frustrated if it's just more onerous or more expensive or indeed more complicated than originally intended. I think where frustration might be more often found is where contractual performance is relatively simple and easy to define. For example, the delivery of a specific one-off good, which is later destroyed, or cancellation of a specific event.
Okay, thanks. So just turning to a slightly different set of questions that have come in. Kate, perhaps I could put this to you. Do you have to, I suppose the question boils down to, do you have to pay for services that you're not receiving? And can you ask customers to pay if you are unable to provide a service?
Sure. So I obviously mentioned earlier that lots of suppliers at the moment aren't able to continue operating. And if that's covered as a force majeure event in the contract, then typically this will mean that the supplier won't be held to be in breach of contract for failure to provide the services. But equally, that means that the supplier may not charge you for services which it hasn't supplied. The principle's the same in reverse. So if you're prevented from supplying services to your customer, then typically you're not going to be able to charge your customer for services which you haven't supplied. But again, I would caveat that by saying always refer back to the contract. John alluded to it earlier. Don't just assume because you're not being provided with the services that you don't have to pay, as there are still exceptions where charges can be levied by suppliers even if services aren't being provided. In some cases, force majeure might excuse non-performance by the supplier, but still require the customer to pay. Utilities contracts are quite a good example of this, where you might see this sort of provision where you have to continue paying your supplier even when you aren't receiving the services. So the key here is to look really carefully at the definition of what you're paying for in the contract. Are you paying, for example, an annual fee, or are you paying for services delivered? If it's the former, then you may well still have to pay.
Okay. Now, John, I can see that one of the questions that has come in during this session relates to, I suppose if a supplier has been able to supply the service or goods, but the customer isn't ready to take delivery, or perhaps for some other reason doesn't want to pay. So John, the question is, I think it looks as if it's in a slightly construction situation using a JCT contract where the subcontractor looks as if it's an air conditioning supplier, has done all the work and is looking for payment probably before the overall job is finished. So it looks as if that supplier was able to do his bit of the job, but the higher up the supply chain, they're not ready to accept it or pay or take payment. So in that kind of situation, John, is that a fair question to put to you?
Yeah, absolutely. And it's a really common example actually of where we're seeing people asking for informal variations to agreements. Now, it sounds to me in that agreement that actually the nominated subcontractor isn't entitled to payment, but is asking for a variation, presumably for some form of cash flow reasons. And we're seeing clients take kind of one of two different approaches. I think normally, cash flow is always king. But a lot of our clients are saying, look, ultimately, if we're not contractually obliged to pay you, we're not paying you early. But I think the second approach some parties are seeing is if it's a really valued supplier and actually, they are a smaller supplier, perhaps one that may be forced out of business, we are seeing some clients say, well, actually, we'll pay you early because actually it's more important for us to be able to continue this commercial relationship with you and have you survive through this process than it is for us to be relying on our strict contractual obligations. I think the caveat is that it sounds to me that legally that contractor isn't entitled to be asking for advance payment, but practically, it may be that the parties are willing to agree a variation. As a litigator, I have to give a word of warning that if you agree any kind of side agreements or anything along those lines, please do document it carefully because the number of times it's kind of agreed in an exchange of emails and then later the wheels seem to fall off. I think, it happens at the best of times. And when we come out of this, people are going to be looking to take every little point on cash flow that they can.
Sure, yeah. So that's interesting you say that, actually. I mean, certainly as a commercial lawyer, I'm more used to the collaboration of putting deals together. And I've seen that people are not wanting, they realise that everybody's in it together and want to maintain relationships for future trading, etc., etc. So, what are you seeing in terms of supplier disputes, and how are people resolving those when they come up?
Yeah, unusually for me, there is a little bit of optimism because even as a litigator, we are actually seeing that people want to know their rights, but the litigation or the threat of it at the moment is a step too far. Ultimately, it kind of almost goes back to the JCT question. People want to know what their rights are, but are more focused on maintaining relationship with key customers and suppliers and acknowledging that this will end. Now, I suppose, to mirror that, there is, perhaps cause to be less optimistic where some of our clients are becoming increasingly focused on preserving cash flow. In some instances, that's actually been refusing to pay sums they accept are legitimately due and owing just to help maintain regular cash flow. But I think, one of the more creative solutions we've seen is trying to use government support to come up with creative solutions. So, for example, one client had a supply contract which it didn't want to carry on paying 100% of. Now, that supplier could take advantage of the 80% furlough scheme. And actually, the customer said to them, we will top up that scheme for you so that you are not left out of pocket, but we're not paying 100% for the services during this interim period. So there are people coming up with some really creative solutions and using that government support as, I suppose, leverage that financially.
Very good. Thank you very much. Well, drawing on all of that you've said, I'm going to perhaps put you on the spot a bit and ask for top tips based on your experience. Kate, would you be able to just give your few top tips?
Yeah, okay. So my top tips. So first of all, as I said at the very start of this, always check the specific terms of your contract. Every situation is different. Don't automatically assume, for example, that force majeure applies, or that because one side's obligations are suspended, so are yours. Make sure you're checking your contract so you know exactly what your options are in that regard. Secondly, make sure that you're talking to your suppliers and customers. We're in this really unique and unprecedented situation at the moment, and you want to ensure that you're keeping your key relationships preserved. And thirdly, as part of preserving those relationships, when you are talking to suppliers and customers, make sure that you're being commercial and pragmatic.
Great, good tips, thanks. John, what about you?
I think for me, always slightly more pessimistic. I suppose the fact that a contract becomes more expensive or less profitable will generally not offer you relief. And I think that's the key one that I would say to take away. But also, I suppose, if you want to go on the offensive, check the notice provisions, because, with lockdown, a lot of people are emailing notices of force majeure, etc., and aren't checking those specific provisions within the contract that say, for example, a notice must be sent by registered post, must be sent to a registered office, whatever it may be. And actually, if you've got someone challenging you and issuing you with force majeure notices, looking at those contractual provisions around what a valid notice is might give you an ability to kick out a force majeure notice on a technicality. And I suppose finally, I think this will come to an end. So keep talking, even if that has to be, through virtual means. And don't forget the government support is there and will help businesses tremendously. So try and think creatively in terms of coming to solutions with your customers and suppliers. But please, please, please write those down when you get to those agreements.
Okay, great. Thanks very much. Just looking, we've got a few minutes, just see any more questions that have come in. About frustration again. What happens if I think a contract is frustrated, but I'm wrong?
Yeah, I mean that's actually a really high risk strategy. So getting frustration wrong is essentially meaning that you're saying to the other party, we are going to refuse to comply with our obligations because we think the contract's been frustrated. Now, if you get that wrong, you are likely to be in breach, which will entitle the other party to terminate the contract and claim for damages. So it is a really high risk strategy.
Well, okay. And let me see, there's one. Well, actually, we're running out of time, but let's see if we can just do one of these. Where the contract does not have a force majeure. Kate, can you look at this? If there's no force majeure clause in the contract, would the court look at what the parties intended at the time the contract was entered into?
So if you have no force majeure clause at all in the contract, then you simply can't rely on force majeure. It's not implied by the law in any way. So if you want to rely on force majeure, it would need to be specifically within the contract.
Right, okay. And John, here's a question, if I could put this to you. If statutory regulations change due to government legislation on self-distancing, for example, would that allow a subcontractor to claim for extra costs in relation to those changing regulations rather than relying on force majeure itself?
Yeah, if you've got a fixed price contract, then the answer is no. And it almost kind of brings the session to an end as we introduced it, which is that the force majeure clauses and indeed the contractual document as a whole expressly allocates risk. And if you've agreed an express price for a contract and actually something has changed to make that less profitable for one party or more expensive to perform for one party, unfortunately the general position is that will be just tough luck for that subcontractor. Now the only exception to that is if this isn't a fixed price contract and somehow it's based on time incurred, where you could envisage extra costs being charged. But generally, if it's a fixed price contract, unfortunately, the court won't have any sympathy that it has become more expensive to perform.
Great. Oh, thank you very much. Thank you. Well, I'm sorry we haven't been able to get to all of the questions that have come through. Time's run out. So thank you, everybody, for joining us again on this webinar. Hope to see you at the next one, which we're doing next Wednesday. Please do keep an eye on our website. That'll tell you what's happening. And do tell us what you know, what you like, what you want, and how they're going. But for the time being, thank you very much, John. John, he's quite a jolly fellow. He's not always so pessimistic. And Kate, thank you both very much. Let me say again to everybody, this is going to end. Let's be ready for that. Lovely to see you all. Thank you very much. Goodbye for now.